Next item. Dr. Gerber?
Yes.
This is yours.
This particular action is in response to a letter we received from an attorney representing one of our patrons who is interpreting the Open Records Act differently from our attorney. We basically, as Cheryl had mentioned earlier, that once our attorney gives an opinion on an issue that has no court record on it, that attorney's opinion becomes what we typically would go by. We have a second different opinion from this particular attorney, from one of our patrons, and in looking at that, I felt like it would be necessary to maybe get a third-party attorney to look at all this and direct us. Say, you know, do we release it, and how do we release it if we're supposed to, or should we not release it? And I would prefer to do that as an approach rather than end up in court. And that's why I'm bringing that tonight. The attorney firm that I've contacted is Crowe and Dunlevy, and they do a number of schools, but they also do Norman Public Schools, another large school district. And they would simply and solely represent us in just looking at the release of attorney billing records. And that would be the sum total of what they would do, and then they would be finished.
How much do they charge an hour?
It's equivalent to what our FR charges, about $200 an hour, depending on the person.
Where's their office located?
It's in Oklahoma City.
Have we given any consideration to using Laura's?
I started to say they do have an attorney here too. I'm sorry, I should have mentioned that. They do have an office
personally,
here as
for
well.
me, I would just assume we get a bunch of black markers, don't pay $250, black out the DAC, whatever we need to do, and just give them out. I mean, I'm tired of this. I'm tired of taking money away from the classroom. My opinion is real simple. Give them what they want. That's my opinion.
In our policy, in our code of ethics, our board code of ethics, number 10 talks about complying with the spirit as well as the letter of the Open Meeting and Open Records Act. And I don't know, I think the appearance is that we're trying to hide something. I don't think I don't know if are we trying to hide something? Obviously, I would hope that we're not. And so I don't know why we can't redact it. But given, if that's not possible, I'm sorry, did you have...
Well, I was just going to say, I mean, it may be that the guidance from this firm may say, here's what you redact and provide it. I don't know.
Rather than spending more on attorney's fees, I would like to provide this letter to the Attorney General and ask for an opinion from him. He is the public's attorney. He doesn't charge us. As a taxpayer, as a public institution, I think we have I would like to look to him and get an AG opinion, and then we will...
Here's a question on an AG opinion. Not to say that that's not a valid point, Stephanie, but the timelines associated to Attorney General opinions are lengthy. And one of the concerns here is we still continue to have questions. And we do have a legal firm that the board has hired to represent us. And that counsel is making a recommendation to us as a board specific to releasing legal bills and what we can or cannot release. I think what's important here is that if it is our attorney currently, our attorney's opinion that we not release them, I think it makes good sense that we ask another firm their opinion. Now, if that firm comes back and says that they would suggest doing something differently, then certainly the board would have the prerogative to act upon that. We're going to wait much longer if we go to an Attorney General opinion.
Now, I was actually told that we could, there are, and in fact, Mr. Mann referred to two different types of Attorney General opinion, sort of like a rendering official Attorney General statement opinion and an Attorney General opinion. And I can't remember the terminology.
Well, let me say this. An Attorney General opinion, if it's not done by the AG, it's just an opinion.
Well, it's
an opinion just like any other attorney's opinion.
But it would be free.
Well, I'm not discounting that at all. I think you make some good points. The only thing I'm saying is that I think it's important that, given the advice, we've hired legal counsel, and our counsel has advised us not to do it. So we need to act on that counsel until we hear otherwise, and I think it's good practice to say, okay, we need another firm to look at this and give us their advice. You have an outside firm, not RFR, giving the opinion.
Well, I think you make a valid point. I would respectfully disagree.
And that's okay.
I would like to, I just hate to spend more money.
So that, I believe what you were asking about, it's a formal opinion,
Yeah,
which is the law of the land.
which takes a long time.
And an informal opinion,
Right.
which is not the law.
Which is just an
Right. And because I think what we get from an attorney is an informal opinion,
Well,
isn't it?
I just want to go back, because I think some good points have been made here. A formal opinion is rendered by the Attorney General. An assistant opinion is like an opinion of any other. In other words, the Assistant Attorney General is just like an opinion from any other attorney. It doesn't carry the weight of the Attorney General.
But why is it no better? I mean, why is paying this?
Oh, I'm not saying that. I just answered the question. I was just answering.
And that's my question. Because any other law firm is just another attorney giving us an opinion. Why not go to the public attorney's office, get a free opinion?
Well, and I think your point's well taken, but here's something to think about, because we don't know. We haven't contacted anyone to find out maybe how long that might take as well. Because anytime you go through the Attorney General's office, it takes a while to get it done.
And now, and I know nothing, about this, but I was told by someone who acted like they knew something, that actually that could happen very quickly. And so I would rather explore that than spend more money. That would be my recommendation, to do what we can to save money.
The only other issue that I might have with that is whether the patron's attorney would hold off and wait for an attorney general's opinion before filing a lawsuit. And if that's the case, we may not have the time to wait, so.
Well, that's a good question.
Have we had several requests on the same nature?
Yes, in terms of, but from the same people.
Okay. So that's costing money as well, research time, inquiring with the physician. I like the idea of getting an opinion so we can do what's right. I don't think it's anything to do with hiding anything. They're not accepting our district's counsel, so let's get another. Crowe Dunlevy is a very large and reputable firm. I would be interested in hearing their opinion on this. So I'd like to make a motion to approve the law firm of Crowe and Dunlevy for the sole purpose of engagement to advise the board and superintendent and represent the district concerning the release of attorney billing records.
Second.
Been moved and seconded to retain the law firm of Crowe and Dunlevy solely to advise the board in concerning the release of attorney billing records. Please call the roll.
Mrs. Kelly?
Yes.
Mr. Stover?
No.
Mrs. Updike?
No.
Mrs. Wilkins?
Yes.
Mrs. Webley?
Yes. Next item.
On point of information.
Yes, sir.
Madam President, can you have the superintendent make sure that there is no current relationship of representation between RFR and this law firm?
Good point. Point taken. Mr. Stover, can you check that out for us? Thank you. Thank you, Mr. Stover.